welcome to this brief video providing some general feedback on the short essay questions. That's assessment 3 that you undertook in Introduction to Law in Term 3. So let's have a look at each question individually. So the first question required that you critically evaluate the claim that the Commonwealth has usurped the power of the states through the external affairs power. So this is based on materials from week 2. A couple of points to note in terms of the language that's been used in this particular question. So the phrase critically evaluate requires that you look at both sides of the argument. It's then important that you reach an overall view or a conclusion as to whether or not that claim is true, but it is important to look at both sides of the debate rather than present a one-sided argument. Note also the word usurp. What does that mean? Well, if we look it up in the dictionary, there's a number of entries. One of the most common ways in which we use the phrase usurp is to say that someone has taken something illegally or they have taken something by force. Now, in this situation, we're talking about the way that the High Court has interpreted the external affairs power. So that suggests that it can't be taken illegally because the High Court has in effect sanctioned that particular interpretation, and it's certainly not been taken by force. So it must mean the more traditional view of the word usurp, which is to encroach or infringe upon. So here the question is asking you whether or not the Commonwealth has encroached or infringed upon the power of the states through the external affairs power. Now, aside from the fact that it requires you to critically evaluate, you also need to acknowledge that there is a claim here. It's a claim. It's not a proven fact. It's a claim that the Commonwealth has usurped the power of the states. That means that you need to determine whether that claim is actually true or false, and you need to do so with supporting evidence. Now, before you go on to talking about the way in which the High Court has interpreted the external affairs power, you need to provide that background information about the power so that you demonstrate to the marker that you know that, for example, the external affairs power is contained in Section 51 of the Constitution and that it is a concurrent power, so it's a power shared with the states. You then also need to go on and explain that under Section 109 of the Constitution, where there is a conflict between state legislation and federal legislation on a matter that is a concurrent power, then the Commonwealth shall prevail to the extent of the inconsistency. So that means, of course, that if a liberal interpretation of the external affairs power is taken, that means that ultimately the state loses power, because where they're inconsistent, the state legislation gives way to the Commonwealth. Once you have provided that background information, you can then move on to looking at cases that illustrate the extent to which the external affairs power has been interpreted broadly in the High Court. So there's lots of different cases you could have mentioned here, and with the word limit we wouldn't expect you to go into them all, but you would need to reference some of them. So there's a range of cases including things like Kuwata, Commonwealth and Tasmania, which is known as the Tasmanian Dam case, and a range of others that feature in your reading. Now, as you're using these cases to illustrate that there's been a broad interpretation of the external affairs power, you would essentially need to focus on the judgments in those cases. So you'd need to provide a summary of what the issue was, and then focus on what the High Court said in relation to how the external affairs power should be interpreted, and how the Commonwealth legislation, the relevant Commonwealth legislation, was therefore regarded as being within the external affairs power, which meant that, of course, ultimately the states would be unable to legislate on that where the state legislation was inconsistent with the Commonwealth legislation. So you can then show through the outcome of that litigation how a broad interpretation of the external affairs power leads to a lack of power or a reduction in power for the states. And that will involve reference to a number of cases where the High Court has arguably expanded the reach of the external affairs power and therefore also increased the scope of the Commonwealth's power to the detriment of the states. Now, as I already mentioned, you would want those cases from the High Court, but you'd also want journal commentary on the High Court decisions. So a lot has been written about those decisions at the time that they were produced because they were recognised by academics as potentially expanding the reach of the Commonwealth. So peer-reviewed journal articles that you'll find in those legal databases would also be really great sources to use in support of your discussions. Moving now on to question 2, you are required to explore whether all Australian law schools should run law clinics that offer free legal advice to the local community to ensure that law graduates undertake pro bono work prior to admission as a lawyer. Quite a lengthy question there. It's obviously based on the materials we covered in week 9, and the first thing to note is that the word explore is one of those neutral phrases which implies that you need to engage in an evaluation of both sides. It can't be one-sided. So in this instance we would be looking at, for example, the pros and cons of law schools being required to offer clinics, and the pros and cons of students being required to undertake pro bono work prior to admission. There are in essence 2 parts. So part 1 focuses on the law schools and whether they should be obligated to run those law clinics. And implicit within that is the question as to why that's necessary. Why do we need law schools to run these free legal advice clinics for the community? So there you need to be talking about the fact that there is a massive shortage in funding for legal aid, that there are large numbers of people who can't gain access to justice. So that really invites you to bring in all of those statistics and research around the access to justice gap and why that's problematic. And then when you've done that, when you've provided that foundational information, you can then look at whether or not law schools should be made to assist with filling that gap or bridging that gap. So what are the advantages of law schools being required to offer these free legal advice clinics, and what are the disadvantages of that? And there are lots of different things that you can talk about here. Some of them are practical and relate to financial issues, and then others are more social oriented. So it's about centering the clinic in the community and providing the university with a connection to that local community. And of course universities are required to serve their communities. And then we've got the second part of the question, which then focuses on law students more specifically and whether they should be obligated to undertake pro bono work as part of their process of being admitted as a lawyer. Again, that requires you to really look at the advantages and disadvantages of this, and you can talk about other jurisdictions where pro bono work is a requirement, and you can look at the extent to which that helps bridge that gap, but what are the negatives or the fallout of those requirements in terms of stretching students too far, whether they're appropriately qualified, insurance-related issues, and issues around ethics and all of those kinds of things, and then the advantages to the students of gaining that experience and the advantages to the community. And once you've gone through that debate from both sides, you should reach an overall view as to this on both points. So should law schools be required to provide free legal advice via a clinic, and should law students be obligated to undertake pro bono work prior to admission? Now, you can answer yes to one and no to the other. That's perfectly fine. You can say that law schools have to have a clinic that's up and running, but say that not all law students should be required to participate in it. Or you could say that law clinics are not necessary, or are undesirable, but law students should have to engage in some pro bono work prior to admission. So it's really up to you where you go with that. Just make sure that your comments are consistent with what you've said throughout. In addition, we were looking for you to cite a range of sources in support, so statistics, journal articles that have looked at the value of pro bono work to law students, the value of law clinics to universities and communities, but also looked at that access to justice gap and how we might bridge that gap. So really looking at a range of sources that support your arguments there. moving on to question 3, this is focused on the Lawyer X scandal. So the question is, critically analyse whether Nicola Gobbo's decision to act as a police informant at the height of the Melbourne Gangland Wars was justified in the circumstances. Now again, the phrase critically analyse is used, so that requires you to look at both sides of the argument. Now right at the outset, in your introduction, you need to identify what you think the phrase justified in the circumstances means, or how you're going to explore the content in relation to that aspect of the question. Because obviously justified in the circumstances could mean morally, but justified in the circumstances also has to relate to the legal aspect and the professional conduct aspect of this question. So there are legal implications for a lawyer acting as a police informant in relation to things like the rule of law, the administration of justice, the right to a fair trial, and there are also professional conduct rules that may have been breached by Nicola Gobbo in acting as a police informant. Those aspects have to appear in your essay to comprehensively address whether or not she was justified to act as a police informant, because those are obligations and concepts that sit around the role of the lawyer. If you are going to add in there moral discussions, then you need to make that clear in the introduction. Now obviously there was a wealth of material on this because it's a really recent area of discussion, because the Royal Commission has just handed down its findings in relation to the Lawyer X scandal. When you're looking at the sources in support of your discussions, it is important though to make sure that they come from reliable sources, not just a blog or a random news item on the topic. It's important that you use reputable news sources if you are going to look to news sources, and ideally you should be using peer-reviewed journal articles and also the findings of the Royal Commission to really support what you're saying. Overall, this question was done really quite well. Occasionally students just focused on the legal implications and the administration of justice without the professional ethics component, but overall the arguments made in this particular question were sound. The only issue that we really saw with this question was that sometimes the sources weren't really credible, they weren't really reliable, because they were news sources that hadn't necessarily been fact-checked, or alternatively, they were just opinion-based pieces, so journalists' opinion on the topic, rather than it being focused on reporting factual events and findings. In these last few slides, I'm just going to focus on some general observations about use of sources, the way that the material is expressed, layout, structure, etc. So first, let's talk about the types of sources that students were using in support of their arguments in their essays. It's really important that when you're looking at secondary sources, so not cases and not legislation, but secondary sources, that you focus on whether or not they are reliable and scholarly. So we would say things like peer-reviewed journal articles are reliable because they've been through that peer review process, which means that they've been scrutinised. Government websites are generally reliable. So, for example, the Australian Bureau of Statistics, all of the statistics on there are credible and can be used in essays. The relevant websites of government departments or ministries, again, can be a useful source of information. And reports of law commissions across the states and territories also often have a great deal of very thoroughly researched information. And of course, we've got royal commissions, such as the recent Royal Commission into Aged Care, for example, or the Royal Commission on the use of police informants in Victoria. All of those are, again, well researched and thoroughly analysed in terms of the credibility of the information that features in those reports. Also, websites of international organisations like the UN would also be a good place to go for information. But general websites, general blogs, those kinds of things are not going to be reliable and scholarly, and therefore you should avoid those wherever possible and look for an alternative. When you're looking at news articles, whether that's in print or on a website, make sure that they are fact-checked and really analyze them. Do you think that they're biased? Are they just a viewpoint or an opinion piece? Do they appear to advocate for a particular position rather than being balanced investigative journalism? Because that may also affect whether or not that is a suitable source to use in support of your arguments. It's really important when you're considering using any source that you think about where you might find a better alternative source, and that you also engage in an evaluation of the reliability of that source. One of the ways that you can evaluate whether a source is reliable and therefore you can use it in your work is to ask yourself the following questions. Is the author of that work recognized as an expert in the field? What's the author's reputation? Is the work for a general audience, or is it an academic audience? Note that it's more likely to be valuable if it's written for an academic audience, as other academics are likely to scrutinize the content, which means that the content will be more carefully constructed. You can also ask yourself whether the source is current and up to date. And we find a huge issue with things like websites because they hang around in cyberspace even when the content's no longer relevant. And note that if a website has had a lot of traffic in the past, it's going to feature at the top of a search engine result list even if it's no longer current and up to date. Ask yourself whether the source provides an objective and balanced evaluation. If it lacks objectivity, then that suggests that it's not going to be a reliable source. Ask yourself also whether it cites sources in support of the argument. So in the text itself, what sources appear in the work? For example, if it only cites other blogs or other websites, that's going to be far less credible than, say, an academic's blog that refers to a variety of recent peer-reviewed journal articles as part of the blog. And finally, ask yourself what your overall impression of the quality of the work is. Does it appear to be an accurate and reliable source overall? Now that might seem like a lot of work, but at the same time it ensures that you're producing a piece of work that is well researched and backed up by suitable, reliable sources in support. I know that some of you said that you were struggling to find sources in support of what you were saying, but it's really important that you do two things. And the first is that you start with the basics, so either the course materials, if they have covered that particular topic, go back to those and see what sources are mentioned in those course materials. The next thing to do is also use the legal databases or the databases in the library, which have access to multidisciplinary journals as well, to search for the material that you want rather than just putting in a couple of search terms on Google, because you're going to find more targeted sources in the library search. First of all, it will take you primarily to journal articles, but it will also make sure that it's honed in on your particular topic, whereas a Google search will trawl the internet for everything that mentions those terms that you have put into the search bar. Once you find a suitable secondary source, it's a really good idea to then look at its footnotes, the sources that are cited in that paper, because you can then use that journal article to help you locate further material on the topic. So once you see a list of sources in a journal article, go and actually find those journal articles and read those as well. So just one source can actually provide a number of research paths where you can go and locate a range of suitable resources. And of course, if you need any help with research, please do get in contact with the librarians. They're really an underused resource at CQU, and they really are excellent at giving demonstrations and talking you through brainstorming ideas as to how you can locate the materials that you need. Our final slide for today, looking at things such as structure and expression. The first thing to note is that we really needed a brief introduction for each essay, which should indicate the key areas of discussion that will feature in your paper. And that is really important when you have to interpret the wording of the question. So if you have had to decide whether to interpret it one way or another, you should clearly state this in the introduction so that the reader has your interpretation in mind when they read what you have discussed. In addition, make sure that you reach a conclusion that aligns with your commentary throughout the document. Also, expression is very, very important. All the knowledge in the world is absolutely useless if you can't communicate it to someone. So it's really important that you demonstrate to the marker through your written communication that you know the law and you can apply the law or you can critique the law. So stick to short sentences, 1 point per sentence. In addition, make sure that you are really focusing on one argument or one area of discussion per paragraph. It's easier for the reader to follow what you are saying if you break those arguments up into a series of paragraphs. Make sure that you use headings. They're really signposts for the reader that tells the reader what you will explore in the content that follows. And it also enables the reader to go back and read just a particular section that they're really interested in, or review what you're saying in that section if they're trying to decide on a mark. Note that the headings should also align with the key areas of discussion that you have flagged in the introduction. And finally, make sure that you proofread your work. I know that sometimes we're up against deadlines, but proofreading always produces a better document. If you submit something that has lots of typos, lots of referencing errors, it immediately creates the impression in the marker that you didn't plan your time properly and you were throwing it all together shortly before the deadline. So please make sure that you proofread your work and edit it appropriately so that it is not just an example of your knowledge and ability to critique the law or apply the law, but also that it shows the amount of time and effort that you've actually put into that piece of work. Okay, that brings me to the end of this video. I hope it's been helpful in reviewing some of the things that needed to feature in those short essay questions. If you have any questions though, please feel free to message me. I'm still on our MS Teams site, or you can email me. And I wish you lots of luck with the rest of your units, and I hope to see you in legal research or one of the other units that I teach in your second or third year.